Welcome everyone. It is Friday, February 24th, 2 p.m. It is, we're here in conference room 325 at the State Capitol, and this is the hearing of the House Committee on Judiciary and Hawaiian Affairs. My name is David Tarnas. I am the chair. To my right is Vice Chair Greg Takayama. To my left is Member Vice Speaker Gregor Iligan, and we have here to my far right Representative Kanani Souza. We're here for the purposes of hearing a number of bills, but before we get started, I just wanted to ask those who are providing testimony, if you could please limit your testimony to 2 minutes. I'll ask you to wrap up at that time, summarize, and that way we can get through all of the testifiers and have time for deliberations and discussion, questions, and then we'll go into decision making. For those who are testifying on Zoom, if you would please make sure you're muted and your video is off until I call you to testify, at which time you can turn on your camera and your microphone, provide your testimony, and then when you're finished, please turn off your camera and your microphone. If you have any trouble and you need to contact the technical staff, just use the chat function on Zoom and you can get through to the technical staff. Don't send me any message on that text because I won't get it. But I will call you to testify so that, and if you for some reason lose your connection and you disappear, just don't panic, come back in as soon as you can and I'll try to fit you back in so you can provide testimony when you return. If you're on Zoom and you're using a background, please make sure it's not trademark or copyrighted, because if you use that, YouTube bounces us off. We can't do that. So that if you would help us out by not using any trademark or copyrighted background. I would request that everyone treat each other with respect and with aloha. We are working together for the people of Hawaii. It's okay to disagree, but let's not be disagreeable. We're just trying to get our work done and work efficiently, and I will do my best to move us through this so that we can all finish up on our Friday afternoon's work and move on to the next thing. With that, I'd like to go ahead and move into our first measure, which is HB 581, relating to child custody. It requires certain individuals attempting to serve as child custody evaluators to complete a training course on the dynamics of domestic violence every 3 years. It requires individuals to submit a letter or certificate of completion to the family court, establishes standards for evaluations and reports by child custody evaluators. First up, we have testimony with comments from Matthew Viola. And I refer the members to the written testimony with comments. And we have testimony in support from Angelina Mercado, Hawaii State Coalition Against Domestic Violence. Please come up to the podium. The floor is yours. Please proceed.
Aloha Chair, Vice Chair, committee members. I'm Angelina Mercado, Executive Director of the Hawaii State Coalition Against Domestic Violence. And on behalf of our 28-member programs, we respectfully submit our support for this measure, which would allow, would require training for custody evaluators. And we actually request that the committee redact one section of this measure that was introduced in the last committee, and it is Section D relating to appointing a custody evaluator, and it goes into some detail about how they should be fair and impartial. And this has been a measure that has been worked with the judiciary in conjunction with coalition domestic violence program members, and we feel that this is really not germane to the actual purpose of this measure. The purpose of this measure is to establish what the training in domestic violence should be for custody evaluators and best interest fact finders as defined in the statute. There is in the best interest of child statute, section 571-46.4, requiring the judiciary to establish a committee to actually work on those things. addressed in that particular section, and it is the ethics, the standards of practice, etc. We are part of that working group, and it's just begun, so we're respectfully asking that this be taken out of the measure and that we proceed as intended, which is really just to talk about domestic violence training for custody evaluators. And obviously here for any questions you may have. Aloha.
Thank you very much. I'd like also just to explain, in Judge Viola's testimony, their request was to make amendments, page 3, lines 1 to 3, to delete the section that says establish standards for evaluations and reports by child custody evaluators in contested custody dispute cases. On page 3, line 7, delete the word standards, and then on page 5, lines 11 to and including line 19, to delete the entire section D. And that actually is the same recommendation that Ms. Mercado was just recommending as well. So I just want to make sure everyone understood that was Judge Viola's testimony. Okay, next testimony in opposition from the Hawaii Coalition for Child Protective Reform. They actually have very similar testimony as the Hawaii State Coalition Against Domestic Violence. Keopu Relitz, Hawaii Children's Action Network Speaks, Hawaii Women's Coalition, and then testimony in opposition from Derek Carlin, Chantil Kalaruda, Caroline Kunitake, and Lori Tochiki. I misspoke. Marilyn Yamamoto, Hawaii Coalition for Child Protective Reform, is testimony in opposition. So let me make that clear. Okay, those are the testimony that we received. Is there anyone else here wishing to testify on HB 581? If not, questions, members? Seeing none, we'll move on. Thank you. Okay, next we have House Bill 448 relating to minors. Provides that, subject to certain requirements, a domestic violence victim advocate or other mental health professional licensed by the state may petition for a protective order on a minor's behalf when the minor's parent or guardian is unwilling or unable to submit a petition. First up, we have testimony with comments from the Department of Education. Welcome. The floor is yours. Please proceed.
Aloha Chair, Vice Chair. Annie Kalama, Office of Student Support Services, Assistant Superintendent, testifying on behalf of the Department of Education. So we stand on our written testimony offering comments, and we're here if you have any questions. Thank you.
Could you briefly summarize your comments for those who are watching?
Sure. So we are basically supporting and appreciating HD revisions that remove school counselors from this requirement.
Okay, thank you. Next, we have testimony with comments from Angelina Mercado, Hawaii State Coalition Against Domestic Violence. Please proceed.
Aloha Chair, Vice Chair, committee members, Angelina Mercado, Executive Director of the Hawaii State Coalition Against Domestic Violence. On behalf of our 28-member programs, some of whom also submitted testimony in opposition to this bill, we originally had comments to this bill, but as written, we actually oppose it, and we respectfully request that the entire section that refers to school counselors, mental health professionals, and especially domestic violence advocates be stricken from this measure. We have significant concerns about the way that this measure is written. As written, we recognize that minors are victims of dating violence and domestic violence. We know that. Our programs deal with that. However, when we put a domestic violence advocate and their program in the position of having to act on behalf of their parent without that parent's knowing, we are actually jeopardizing that program itself. And we're potentially jeopardizing the ability of our domestic violence advocates that are given privilege under our state victim counsel privilege statute, the ability to have a confidential conversation with those survivors. And it would basically have the unintended consequences of really having advocates and programs unavailable to those very minors who desperately need these services. Instead, what we recommend is that we write in statute the ability for a minor who is 16 or older, or a minor who has been emancipated, and there is a measure that is going through our legislature that would allow a minor at the age of 16 or older to be emancipated, to actually be able to petition for a protective order on their own behalf. They would still have access to our domestic violence advocates. They can still go to the family court, for instance, in the First Circuit in Kapolei, and have access to some of our programs, domestic violence advocates, and we think that is in the best interest of programs, long-term services to survivors, and the ability for minors to get the protective measures that they need.
Thank you.
Thank you.
Thank you very much. Next, we have testimony with comments from Ryan Kusumoto, Parents and Children Together, testimony in opposition from Child and Family Service, testimony in support from Ellen Godby Carson, in opposition from Derek Carlin and Marilyn Yamamoto, in support from Marianne Castro, Alan Garcia, and Lisa Smith, testimony with comments from Vanessa Corwin, testimony in support from Chelsea Stewart. Is there anyone else here wishing to testify on HB 448? Please come on up, introduce yourself. The floor is yours.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the House Committee on Judiciary and Hawaiian Affairs. My name is Vanessa Corwin, and I'm here speaking as a former domestic violence and sexual assault advocate, and I have 8 years of experience in this field. And while I understand the intent of this proposed measure, we know that teen dating violence is an extremely harmful and prevalent issue. I oppose this bill as it is written, and like Angie, I have deep concerns and respectfully suggest amendments. So this bill would allow domestic violence victim advocates or other mental health professionals to petition for a protective order on behalf of a minor, specifically if their parents or legal guardian is unwilling or unable to petition on their behalf. And as some background information, victim advocates have the role of providing free and confidential support to survivors by ensuring that they know their rights and options available to them, and to help them navigate safety and healing. Advocates are there to empower survivors to make decisions for themselves because they are experts in their own relationships. And as a former advocate, I have concerns for a few reasons. First, this would create liability for domestic violence programs and their staff, right? The traditional role of an advocate is to provide legal information and accompaniment to court, but not provide legal advice. Second, I believe that there is a potential for unintended consequences of jeopardizing a DV advocate's ability to maintain privilege under the victim counselor statute. And this privilege is really fundamental as it allows survivors the peace of mind knowing that an advocate is someone with whom they can discuss their safety without any possibility of this person sharing that information without their consent. So I respectfully also recommend that the committee consider allowing minors 16 or older to petition for an order of protection without their parent or guardian's consent. I was an advocate in Washington State where the age is 16, and I have worked with teen survivors to go through this process, and I know how empowering it can be for them to take control and take the step towards safety. So I just believe that survivors deserve to have options available to them so that they can make the best decision for their situation. Thank you so much for really having the space to talk about it.
Thank you very much. And members, we do have Ms. Corwin's testimony in our package, so I refer to that as well. Thank you very much for being here in person. Is there anyone else here wishing to testify on this measure? Please come up, introduce yourself. The floor is yours. Please proceed.
Hi, good afternoon. My name is Chelsea Stewart. I submitted written testimony last night, but I just
Yes, we do have it.
I do want to clarify that I am opposed to the bill as it is currently written, but I do support amendments. Like Vanessa Corwin, I am also a former victim advocate, and I'm speaking in that capacity. I have about 4 years total of direct case management experience, as well as working at a domestic violence hotline. My biggest concern with the way that it is written is that it might create some safety concerns, especially in regards to retaliation, not only for the domestic violence program, but for the advocate themselves. Specifically, like if there's a situation where if a parent or legal guardian refuses to file a petition on behalf of their minor, and later finds out that another adult, like a victim advocate or a counselor, files on their behalf, it's just going to create a lot of retaliation for the advocate and the program. So that is my main concern. I don't want to speak too much. I know I have limited time, but my other concerns have already been summarized by the people who spoke before me. I do believe that it does create potential liability for the domestic violence programs and the advocates. And it's going to create a lot of, it might actually create more additional boundaries between the confidentiality services that victim advocates provide and the minors, the teens and young adults that they serve. So I suggest amendments. I support the amendments, maybe to state that allowing minors age 16 years or younger to file an order, to be allowed to file an order for protection on their own without the parent or legal guardian's consent. All right, thank you.
Thank you very much. Appreciate your testimony in person, and we do have your testimony in writing. It's very helpful. Anyone else here wishing to testify on House Bill 448? If not, questions, members?
Chair, I have a question.
Please, go ahead. Vice Speaker.
Thank you, Chair. Ms. Mercado, I wanted to ask you about your amendment regarding 16 of age.
Mm-hmm.
Why 16? What makes that number the number?
Great question. So we actually worked with one of our national technical assistance providers, the National Center on Protective Orders and Full Faith and Credit, and they've actually done an entire grid of which states allow minors to have access to protective orders, and we found that about 9 of them allow them explicitly without their parents' consent. We found that some states like California allow a minor as young as 12 years old, and some other states as young as 14, and we thought it was sort of that appropriate level where a minor might be able to speak on their own behalf, and obviously they're already in a situation where they feel like they are in danger and need access to safety, and can seek these services on their own and can do so independently. Anything younger would probably require a lot more engagement from the court system and the community.
Do you know which states are currently applying that 16 years old minor?
It's in the testimony. You've got.
I don't have them all 16, but I can probably pull for you. Hold on a second.
In your testimony, it's got following 9 states already have laws in place allow minors of various ages to petition for protective order without parent or legal guardian. That's District of Columbia, Minnesota, Missouri, New Hampshire, Oklahoma, Oregon, Texas, Vermont, and Washington. Right,
so California is 12 years old.
Thank you, Chair.
Do you need want me to go through this?
Oh, no.
Okay.
Thank you.
Okay, great, thank you.
Other questions, members? Great questions. Thanks very much, Representative Iligan. Okay, and if there's no more questions, we'll move on to the next measure, House Bill 470, relating to minors, repeals the sunset date of Act 23, Session Laws of Hawaii 2021. First up, we have testimony with comments from the Department of Human Services. Welcome. Please introduce yourself. The floor is yours. Please proceed.
All right, thank you. Aloha and good afternoon, Chair and Vice Chair and members of the committee. My name is Tim Hitchens. I'm the Assistant Administrator for the Social Services Division on behalf of the Department of Human Services today. And we stand on our written testimony, and I'll just highlight a couple points. I think our biggest concern is with the licensure piece. So we strongly believe that to ensure the safety and well-being of minors to the extent possible, the Department's position is that any individual, organization, or institution providing substitute care for children or youth in Hawaii must have appropriate oversight. To comply with the federal regulations and state law, DHS offers 3 basic types of licensure. One is resource family homes, where we're looking at typically foster homes that can house up to 5 children or 6 to accommodate sibling groups. Then we have child care institutions for larger groups intended for short-term stays. And then we offer licensure for child placing organizations, which are typically organizations through the Department of Health who are meeting therapeutic needs of youth, and then we can certify or license those homes. The only other type of certification we're aware of is a federal certification or a federal program to house emergency youth shelters under the Runaway and Homeless Youth Program, 45 CFR 1351, and they have specific guidelines that do require licensure of the state where the facilities operate. So we stand by that and believe that the licensure is really an important piece to incorporate into Act 23. And I'm available for any additional questions that you may have.
If I may, you also note in your testimony that you're seeking to add a provision to this, to section 346-17.6H HRS, which is in another bill, HB 223, so at the bottom of page 2. Could you just go over that briefly?
Sure. So this piece here, this was with the support of the Administration for Children and Families. They recommended language here that ensures that anyone that's housing youth will communicate with appropriate jurisdictions who may have custody, including the Department of Human Services or delinquent facilities, or I should say the judiciary.
Okay, and you want that language incorporated into the HRS section that you cite?
Correct. So that section is defining what a provider is, and in there we would like that language.
Got it. That was to keeping all shelter services aligned and compliant with federal regs.
Correct.
That's what you're doing. Okay.
Yes.
All right, thanks for that explanation.
Yep. Sure. Thank you.
Okay, next we have testimony from State of Hawaii Office of Youth Services with comments. And we have testimony and support from Hawaii Youth Services Network, Judith Clark. Please
Aloha,
proceed.
Chair, members of the committee. I'm Judith Clark, Executive Director of Hawaii Youth Services Network. We are in strong support of, the intent of this bill. We have coordinated a statewide runaway and homeless youth partnership since 1981. And we have been the emergency shelter grantee from the Administration for Children and Families throughout that period in partnership with several agencies across the state. We believe that enabling minors to consent for admission to a shelter ensures that they are able to escape the dangers of the streets in those rare situations where consent from a parent or guardian cannot be obtained. In some circumstances, notifying parents or guardians of the minor's location could increase the risk of harm by family members or guardians. Physical, sexual, and emotional abuse committed by a family member or guardian is often the reason why the minor is seeking a safe shelter. We do believe that the focus of services to this population should be to ensure that there are adequate resources to house minors safely and appropriately. We know that Residential Youth Services and Empowerment has provided safe and appropriate shelter to 27 unaccompanied minors since the statute was enacted. And we believe that they should be allowed to continue to provide shelter to this vulnerable population. However, the reason that a sunset clause was included in the legislation was to allow the Department of Human Services to amend its licensing rules to address this issue. Hawaii Youth Services Network believes that the statute should be extended, but not made permanent, so that the Department of Human Services can make any needed rule changes.
If you could summarize,
Thank you for
please.
the opportunity to testify.
Thank you very much. Perfect timing. Thanks, Ms. Clark. Next, we have testimony and support from Michael Golyuk, Stonewall Caucus of the Democratic Party of Hawaii. Please proceed.
Good afternoon and happy Aloha Friday. Yes, the Michael Golyuk Jr., Chair of the Stonewall Caucus of the Democratic Party of Hawaii. We stand in strong support of the initial intent of this legislation. We do have some very problematic problems with the DHS testimony. They have a lot of roundabout stuff in their testimonies. They say Hawaii doesn't have a licensing program for safe havens for homeless unaccompanied minors. That's because DHS has failed to champion such shelters or programs in the 22 years that I've been advocating for something along these lines. They have given me the runaround from administration to administration, and so that we don't feel, that's why we advocated for there not to be a sunset provision in this bill when it was first passed. We oppose any amendments that would require these shelters to make the minor become a ward of the state or enter the foster care system to seek shelter. Other states have safe haven shelters that do not have these requirements, and they are able to help more than 5 minors at a time. DHS needs to change the prime directive about reunification of minors with parents and families at all costs. they need to go with a prime directive of the safety and well-being of the minors, unaccompanied minors, being the first and foremost provision. Had that been the provision, they would have already amended, they have come to this body asking for them to enshrine in law programs and licensing programs to help safe havens, to provide safe havens for unaccompanied minors. We sit here today, that has not happened. We ask you to move this bill forward in its original intent, ignoring DHSS requests for amendments that would weaken this bill to require minors seeking shelter to become wards of the state. Mahalo for your time, and have a good day.
Thank you very much. Next, we have testimony from Carla Hauser, Residential Youth Services and Empowerment. Please proceed.
Aloha, Chair. Carla Hauser, Executive Director with RISE. We stand on our written testimony in support to allow community-based organizations who have a proven track record in working with homeless, unaccompanied minors and their families who give consent for the young people to be with us. We are happy to work with DHS on any issues regarding compliance, safety, zoning issues, but we would like to be able to continue this work and allow young people to not have to enter the child welfare system in order to get shelter. Thank you.
Thank you very much. And next we have testimony and support from Opportunity Youth Action Hawaii, Will Karen and Marilyn Mick. Is there anyone else here wishing to testify on House Bill 470? Seeing none, questions, members? I have a question. Ms. Hauser, let me ask you if I may.
Yes, sir.
In the testimony from the Department of Human Services, they're requesting that we add a provision here that facilities shall also take steps to ensure that youth who are or should be under the legal jurisdiction of the juvenile justice or child welfare systems obtain and receive services from those systems until such time as they are released from the jurisdiction of those systems as required by the Runaway and Homeless Youth Act as amended.
Yes, sir. And
what is your opinion about the effect of incorporating that into the language of this measure?
I am in full agreement. In our current status of operations, we work with both the judiciary, CAMD, Child Welfare Services. In fact, a child welfare worker just left our emergency shelter who is currently working with one of our minors who is actually seeking to enter into child welfare services so that they can have some support when they age out. So I am in full support of any sort of collaboration with the state systems that can support our young people.
Thank you very much. Any other questions, members? Seeing none, we'll move on. Thanks to all the testifiers. Next, we have HB 650, relating to health, authorizes advanced practice registered nurses to practice medical aid in dying or provide counseling to a qualified patient, amends the mandatory waiting period between oral requests and the provision of a prescription, provides an expedited pathway for terminally ill qualified patients who are not expected to survive the mandatory waiting period. First up, we have testimony from the Department of Health. Welcome. Please proceed.
Happy Aloha Friday, Chair, Vice Chair, and committee members, and Vice Speaker. My name is Lauren Kim. I'm the Planning and Policy Officer for the Department of Health. We will stand on our testimony, the gist of which is the issues for which this measure proposes remedies, namely access to participating providers, and the experience of patients who expire before the waiting period can be fulfilled. The department can corroborate that those are by far the overwhelming feedback from participants. The extent to which these specific provisions remedy that, we're just going to need to see and evaluate. The department does provide reports that are posted on our website. The next one is due in the middle of the year. And one last comment for the committee's information. Although this is not part of our testimony, the source of this information is from feedback from providers who participated or tried to participate, and from a summit that is held. Would have been nice to have it every year, but COVID got in the way. But we've had several annual summits where participants and interested parties were invited, and over the course of 2 or 3 hours in the evening, discussed their program experiences and recommendations. So with that, I will stand on my testimony and will be available for questions. Thank you.
Thank you very much. Next, we have testimony and support from the Board of Nursing. Welcome. Please introduce yourself. The floor is yours. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Chelsea Fukunaga. I am testifying on behalf of the Board of Nursing. The board will stand on its written testimony in support and will limit its testimony to the portions pertaining to the inclusion of advanced practice registered nurses. The board supports the bill's intent to remove barriers for the practice of APRNs and, more importantly, to provide greater access to healthcare for Hawaii residents, especially those who reside in rural areas and on the neighbor islands. Thank you.
Thank you very much. Next, we have testimony with comments from the Hawaii State Center for Nursing. Next, we have testimony and support from Hawaii Association of Professional Nurses. Please proceed.
Thank you, Chair and Vice Chair. My name is Bradley Kuo. I am an APRN here in the state. I am the legislative coordinator for the Hawaii Association of Professional Nurses. We would like to stand on our written testimony, and we will be available for any questions. Thank you.
Thank you very much. Next, we have testimony and support from Sarah Manns.
Good afternoon, Chair, Vice Chair, and members of the committee. I'm Sarah Manns, Hawaii State Manager for Compassion and Choices, the nation's oldest and largest consumer-based nonprofit organization working to improve care, expand options, and empower everyone to chart their own end-of-life journey. And I will stand on my written testimony, aside from asking that the committee lift up the written testimony of many individuals, physicians, nurses, APRNs, patients, and patients' families, telling the stories of how the shortage of physicians, particularly on neighbor islands, makes it very, very difficult for patients who want to access this form of care to be able to do so. Thank you.
Thank you very much. Next, we have testimony and support from Samantha Trad. Please proceed.
Thank you. I'm also with Compassion and Choices, and I also stand on my testimony. Our organization helped to pass this law. We've been working with, like Sarah said, doctors, physicians, social workers, nurses, and especially with patients who have had trouble accessing the law. And as Lauren Kim mentioned, the amendments to improve this law came from those people on the ground, especially clinicians who are doing this work. So thank you so much for hearing this bill. And I will stand by if there are any questions. Thank you.
Thank you very much. Next, we have testimony and support from Aubrey Hawk. Welcome. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, members of the committee. I'm Aubrey Hawk. I flew in this morning from East Hawai'i Island. I am grateful for this opportunity to bring into this room the rural residents that we're talking about. One of my roles is as a volunteer patient navigator for patients who are having difficulty accessing the law as it currently is written. I sometimes speak to patients on a weekly basis. By far, they are from neighbor islands. Most recently, I've been dealing with Mr. Jack Bryan, who is a Vietnam veteran from Kea'au. So my neighbor, so to speak, he cannot find a provider. He is with the VA, and of course, the federal government doesn't participate, but even going outside the VA, he's having trouble. He recently mentioned that he might consider going to try to find street drugs to alleviate his suffering, which is heartbreaking. So I'm here for them, and I appreciate your yes vote today.
Thank you very much for your testimony. Thanks for traveling in for the hearing today. Next, we have testimony from Michelle Cantillo, Hawaii Pacific Health. Michael Goliup, Stonewall Caucus, Democratic Party, Hawaii. Please proceed.
Good afternoon again. I'm Michael Goliup, Jr., Chair. We stand in strong support of this legislation. We were proud to be a strong advocate to get this bill passed. We are glad to be back. We're sorry we have to be back here, but we are glad to help make sure that they're gaining access. The one thing we've seen, like with abortion, it may be legal, but it doesn't matter if you don't have access. One of the worst things that we've been hearing from people is that, yeah, it's legal, but I can't access it. And this will help remove those barriers for those that are seeking this for their end-of-life care. We ask that you pass this bill to help those that desperately need it. And thank you.
Thank you very much. Next, we have testimony and support from the Hawaii Society of Clinical Oncology. Testimony in opposition from Hawaii Family Forum. Testimony with comments from the Hawaii Psychological Association. Testimony with comments from the Hawaii Islands Association for Marriage and Family Therapy. Testimony and support from Susan Amina. Testimony in opposition from Jackie Mishler. Please proceed. Jackie Mishler, are you on Zoom? Please proceed.
Can you hear me?
Yes, we hear you now. Go ahead.
So sorry. I'm Jackie Mishler, a board-certified patient advocate and a retired RN from Maui. I've been involved with this and related issues at the legislature now for over 20 years, and was invited to be part of the discussion by Senator Chun Oakland during the creation of the Advanced Directive legislation along with the Office on Aging. Institutional memory. I was there. And I will tell you that more than half the people in Hawaii never wanted assisted suicide and euthanasia to begin with. With passage of the OCOC Act, Honorable Representative Della Abalati promised us that Hawaii would have the strongest safeguards in the nation. If that legislative promise is to be kept, these bills being promoted should be at the very least give us 10 plus years before we start dropping off those promised strong safeguards. The time agreed that it takes to see the effects of issues in legislation. Please remember that less than 2 handfuls of states allow assisted suicide today, and some legislatively deny it, as the Supreme Court left this issue in the states' hands due to their concern about the potential for abuse. There is no proven necessity for reducing the safeguards at this time. Anecdotal stories abound about individuals. The unheard stories here are those of individuals hurt by the legislation, who feel affronted by the medical profession, the society, and anyone suggesting that they take their own life, and those who have felt coerced to do so. Judiciary is about just laws. Even if we grant that PAS and euthanasia would ease suffering in individual cases, we must ask ourselves, what are the risks we run as a society by allowing this measure? Are there alternative ways to alleviate suffering which have lower risks? Nurses cannot, for insurance purposes, write a terminal diagnosis for a patient. Why should we suddenly allow them, who as a profession don't necessarily want it anyway, to write lethal prescriptions? Please seek a solution which will be as good for the patient, but will be better than this plan to expand killing for the society. Keep the promised safeguards until compelling evidence shows us a need to change. It's too soon to see how the unintended consequences and the new victims emerge. Thank you for listening, and please defer this bill.
Thank you very much. Next, we have testimony and support from Ellen Godby Carson, Bob Grossman, Mary Boland, Jane Arnold, Kathleen Johnson, Stephen Chudi, Celine Mercereau, Mary Uyeda, Marguerite Lambert, William Metzger, Stephanie Marshall, Brian Goodyear, Lynn Wilson, Nina Buchanan, Sandra Fujita, and testimony in opposition from Dara Yatsushiro. Testimony in support from the following individuals: Karen Ireland, Ludwig Lab, Joy Rodriguez, Malaki Grange, Georgia Bop, Alberta Freitas Flag, Lynn Matusau, Lawrence Lau, Mary Steiner, Leilani Maxera, Diane Ware. Testimony in opposition from Marsha Berkowitz, and testimony in support from Alan Novak and Eve Anderson. Is there anyone else here wishing to testify on HB 650? If not, questions, members? Yes, Representative Ganadin, please proceed.
I'm not sure who can answer this. Maybe to Ms. Trad, Samantha Trad.
Yes.
Hi, good afternoon. Well, before I start, firstly, thank you to the chair and to committee members for hearing this difficult bill. It's not always easy to talk about these things. There's discussion in your testimony and the testimony of others why we need to reduce the wait time from 20 days to 5 days. And then a discussion about the 17 steps that a terminally ill person must complete in order to get a prescription for medical aid in dying. Can you explain to the committee what those steps are and why, and if those steps are sufficient to meet the needs of the bill and the, I suppose, human rights of the individual, why we need a waiting period at all?
Yes, thank you so much. That's a really important question, Representative. So in order to access medical aid in dying, there are 17 steps, and the steps are from the patient's perspective. So I'll give you the cliff notes of it, and if you want, I can expand more on any part of the process. But in order to obtain it, first of all, a person has to meet all of the core safeguards. That means they have to be mentally capable of making medical decisions. They need to be an adult. They need to be a resident of Hawaii. They need to be terminally ill with 6 months or less to live. And just as a side note, you know, this medication is for people who are imminently dying. And I think one of the most major reasons the waiting period is such a problem is that people don't ask for aid in dying medication until they need it. You know, these people absolutely do not want to die, but their terminal illness has robbed them of life. So to then ask them to wait for 20 days in between 2 requests. So a person has to make 2 oral requests to 1 clinician. Right now it's a physician, and those oral requests have to be separated by 20 days. So this is really like 2 different doctor visits. And if you've tried to go in to see your doctor anytime soon, you know that can be difficult even for people who are healthy and have more time. So they have to see 1 doctor, the one who will ultimately write the prescription, 2 different times, 2 different consultations. This prescribing clinician goes through a laundry list of questions that they ask the patient. Then there is a second consultation by another provider, right now it's a physician, who also asks a laundry list of questions to the patient. They look at the patient's medical record, evaluate the patient, just like the prescribing provider. In Hawaii, it's the only state where there's a mandatory mental health assessment. It's really the 3rd mental health assessment because both the prescribing provider as well as the consulting provider also check for mental capability for decision making. So in Hawaii right now, a psychiatrist, psychologist, or social worker must also evaluate the patient. And like I said, in between the 2 visits with the prescribing doctor, there's a 20-day mandatory minimum waiting period. Hawaii's the only state that has it this long.
Got it.
Yeah.
Thank you, Ms. Shred.
Sure.
Thank you,
There's
Representative.
more steps, but that's a summary.
I appreciate the summary. I know there's a lot more to it, but I appreciate the summary. Any other questions, members? Yes, Representative Ilagan.
Thank you, Chair. I have a question to the Department of Health, Lauren Kim. I wanted to ask about the 20-day waiting period. What was the initial reason for that when our care, our choice?
If I recall, it followed along the lines of what other states were doing at the time. Only Oregon and maybe one other state had it. Oregon has had it for about 20 plus years. And as states' jurisdictions began to look at this, that was a number on which we based on which the sponsor of the bill based that number. Similarly, although the department is not taking a position on any specific number, we are not interested in necessarily being an outlier. So as we are seeing states live with this experience, we are seeing laws amending waiting periods to be a little lower. So to the extent that we are not an outlier, the department supports that conversation, though not necessarily will say it should be X number of days.
Is that why when you made, with the amendment of within 15 days after making the initial oral request, the 5-day waiting period shall be waived? So instead of it making it to 20 days, looking at it not being that baseline, you lowered it to 15 days? What was the reason for that?
I think that there are just a lot of circumstances and variables that can get in the way. So the timeline that Ms. Trad described is if everything works perfectly. Try to get an appointment for yourself for something that's not routine, and that takes time. Try to get an appointment with a psychologist that who's never seen you before.
Maybe I'm not
that takes
clear.
time.
I'm looking at the provision if a qualified patient's attending provider attests that the qualified patient will, or within reasonable medical judgment, die within 15 days, like, wouldn't it be 20 days? Like, why change that period to that death period? And what I'm trying to find out is that you're waiving the 5-day waiting period. After all your calculations on the predicted death of the individual, why was that death at 15 days instead of 20?
Again, we're not endorsing a specific number, but if I could maybe refer you to Ms. Trad, who might be able to answer that question on how the amendment came to specifically 15 days or 5 days.
And the reason why I'm asking, wouldn't you want to be more consistent in keeping that? I mean, I'm guessing that with your experience after the law has passed, knowing some of the variables, I question why you would lower the date when there's uncertainty. Wouldn't you want to maybe raise that time period? But instead you decide to lower it? Oh, what was her name again?
Ms. Trad.
Ms. Trad?
Yes, I'm happy to answer. So the reason the amendments are with these specific dates are based on data that we have from other states. So Oregon was the very first state to pass a law like this, and so all of the other states have modeled their laws after it. And Oregon originally had a 15-day waiting period. They have since seen, because every year departments of health put out reports just like the Hawaii Department of Health, and what they've seen is that about 30% of the people who asked for aid in dying died during that 15-day waiting period. So in Oregon now, they have this amendment where the prescribing provider can actually waive the waiting period if the patient is unlikely to survive it. Now, they still have to go through those 17 steps. Right. So it's still going to take time. In New Mexico and in California, they've both lowered their waiting period to just 48 hours because they found that it's not actually a safeguard. It's really a well-intentioned, unnecessary barrier.
Okay, and that explains the whole 5-day waiting period, why you lowered that to 5 days. I guess, thank you for that explanation. I was hoping that you were going to say that it was based off the findings that you found within our system instead of basing it off of another state, but.
It actually is too. The Hawaii Pacific Health and Kaiser Hawaii have shared their internal data, and they've also found that about 20 to 30% of their patients died during the waiting period, and they felt that so their institutions themselves are not taking a position on the bill, but the doctors like Dr. Miller and Susan Amina, who also has submitted testimony, they felt that that 5 days was a reasonable amount to have a person wait.
Thank you, Ms. Trad, for that additional information.
Yeah.
And Chair, if I may add.
Yes, please.
I think to round out Vice Speaker Iligan's line of questioning, the department does not receive that information on the number of people who expire before reaching the final stage. So that is not a number that we have in our data. The law 328L only requires providers to report patients who successfully made it to the prescription stage. So we have that end. We do not know what the denominator is, so that's just unknown to us. So I hope that helps clarify things.
Okay, thank you. Any other questions, members? If not, thanks very much to all the testifiers on that important measure, 650. Let's move on now. House Bill 642, relating to consumer protection, requires check cashers to report suspected financial exploitation of elders and vulnerable adults in relation to check cashing, provides immunity for good faith reporting, authorizes a check casher to refuse to cash a check in situations of suspected financial exploitation, and it clarifies that all entities that are within the definition of check casher are subject to the requirements for reporting financial exploitation. First up, we have testimony with comments from the Department of Commerce and Consumer Affairs, Office of Consumer Protection. Welcome. The floor is yours. Please proceed.
Thank you. My name is Mana Moriarty. I'm the Executive Director of the Office of Consumer Protection. We submitted comments. The centerpiece of this bill is a requirement that check cashers report to the Office of Consumer Protection whenever they believe or reasonably believe that the financial exploitation of an elder may have occurred, been attempted, or is being attempted. And the stated purpose of the bill is to combat instances of financial exploitation of an elder. At best, we believe this is a very indirect way of getting at the issue that's at the heart of the problem here. And let me explain why. When we talk about financial exploitation, there's a definition in this bill. It's an act or omission to obtain control over the elder's property, to deprive the elder or vulnerable adult of the ownership or use of that property. It's also an act or omission to convert money of the elder. What we're really talking about here is conduct that is probably more accurately characterized as criminal conduct. The Office of Consumer Protection Enforcement Authority is limited to civil law, and we do not have the authority. What we would be essentially being asked to do here would be some sort of pass-through to criminal agencies for reporting misconduct here. A second concern that we have here is that generally speaking, when you want to enact an effective law, you're going to take either the carrot or the stick approach. This bill takes neither. The centerpiece, as I mentioned, is the provision that the check casher shall notify this office, but there's no stick. And already we're aware of situations where, well-meaning individuals are reporting this type of conduct. There's no incentive in this bill for people to report the conduct either. Thank you.
Thank you very much. Next, we have testimony with comments from Iris Ikeda. Welcome. The floor is yours. Please proceed.
Thank you. Aloha. My name is Iris Ikeda. I'm the Commissioner for the Division of Financial Institutions, and we would echo what the Executive Director Moriarty had already said. In addition, we think that the new Part 2 is duplicative of state and federal oversight over banks. Banks are already heavily regulated by DFI and the federal banking agencies, and we will make sure that consumers are held in a safe and sound manner in conducting these transactions with regulatory compliance. We also note that the standard of financial exploitation is a subset of financial abuse, which is what we and the other banking regulators want compliance of. And so, for those reasons, we suggest an amendment to have the exemption in Part 1, Section 5 also apply to Part 2, or to not change Section 5 or the 480F5 and leave it as chapter. Thank you.
Thank you very much. Next, we have testimony with comments from Stephanie Sakamoto, Hawaii Credit Union League. And next, we have testimony with comments from the Hawaii Bankers Association.
Good afternoon, Chair, Vice Chair, and members of the committee. Mihoko Ito on behalf of the Hawaii Bankers Association. Our comments essentially echo that of Division of Financial Institutions. We do believe that this measure is duplicative as to financial institutions who are already subject to mandatory reporting requirements where there is suspected financial exploitation of elders. That's in HRS Chapter 412, and we cited the specific section in our testimony. So we are asking today for an exemption to this measure if the committee is inclined to move it. Thank you very much.
Thank you very much. And next we have testimony and support from Lynn Machasau. Is there anyone else here wishing to testify on HB 642? If not, questions, members? Seeing none, we'll move on. Thanks very much to the testifiers on this measure. Next measure is House Bill 899 relating to health. It designates the month of September as Fetal Alcohol Spectrum Disorder Awareness Month to promote public awareness of the risks of alcohol consumption during pregnancy. First up, we have testimony and support from Daintree Bartoldas, State Council on Developmental Disabilities. Welcome. Please proceed.
Thank you, Chair, Vice Chair, Speaker. My name is Dane Spartalos. I'm the Executive Administrator for the Hawai'i State Council on Developmental Disabilities. Fetal alcohol spectrum disorder is the one developmental disability that's preventable. We're in strong support of this measure. In 2008, the Department of Health under the Family Health Service Branch lost their only fetal alcohol spectrum disorder coordinator position. Since that time, we've seen very little advertisement warning us about the harms of alcohol to an unborn child. Even one drink to a pregnant mom can result in a lifelong developmental disability to that child. Thank you for this opportunity to support.
Thank you very much. Next, we have testimony and support from Darlene Scoville. Please proceed.
Aloha and good afternoon, Chair, Vice Chair, and all the members of this committee. My name is Darlene Chen Scoville, and I am a volunteer advocate for families and children that's impacted with fetal alcohol spectrum disorder. There is power in knowledge. I think, in my opinion, we are aligning Hawaii with the nation and globally with declaring September as an FASD Awareness Month. There are so much misinformation. A lot of people do not know even what fetal alcohol spectrum disorder is. It is the consumption of alcohol during pregnancy. A lot of mothers are clouded with stigma, so they do not come forward to advocate for their children. With having this awareness also will kind of give them an information and a reassurance that it is really not their fault. We can have that information available to those mothers who are clouded with fears. So having this awareness month is crucial. Like I said, this disability is case-specific, cause-specific, and is preventable. So having this awareness month, we can flood our communities, agencies, families, women, and children with the information so that they can make informed decision about that consumption of alcohol, even to reach out for those boys and girls that are non-childbearing years yet. I think we can do this, and we can decrease infants born with FASD in Hawaii. Thank you.
Thank you very much. Thank you for your steadfast advocacy on this measure. Next, we have testimony and support from Lou Erdicek, Hawaii Disability Rights Center. Testimony and support from Cleota Brown, Hawaii Fetal Alcohol Spectrum Disorders Action Group. And testimony and support from Ann Yabusaki, Kenichi Yabusaki, Lisa Smith, and Carolyn Azelski. Is there anyone else wishing to testify on House Bill 899? If not, questions, members? Yes, Representative Ganadin.
I suppose, Mr. Baltodis? With the...
Yes.
Oh, Ms. Baltodis, I'm so sorry.
That's okay.
I'm surprised that we don't have testimony from the Department of Health here. Would you like to amend this bill to include an appropriation so that the department can educate the public?
I would. That would be, yes, that would be awesome.
Well, that was simple then. So that's my suggested HD1, Chair.
Thank you very much.
Thank you.
Thank you.
How, the next question, simplified, how much?
I'm not sure.
I appreciate it.
Okay, we'll keep it alive to discuss it further. Thank you.
Thank you very much. Any other questions, members? Yes, Representative Iligan.
One further question. So September 9th is the National Institute on Alcohol Abuse and Alcoholism Day.
Mm-hmm.
Is there a day that is currently celebrated for what was it?
I've only seen a month. I haven't seen a day. Maybe, and I'm sorry, just a month.
Okay. And I'm guessing you're going to be using your agency's funds to be able to spread that awareness?
Yes.
And you already have the allocated funds for that?
Not as much as we could use.
Okay.
Thank you very much. Any other questions, members? Thank you. I would just note for members that we're not able to add money to this bill just because it would have to go to finance, it'd be re-referred, and we've already passed the deadline for putting money into a bill that didn't have it before. So good idea, but we need to have thought about this earlier and make it happen. So just keep that in mind. Okay, any other questions on this measure? 899? If not, we'll move on. Thank you very much to the advocates. Next, we have House Bill 1485 relating to the election of the president. Establishes a date for presidential primaries as well as signature and fee requirements for a person to be nominated as a presidential primary candidate. First up, we have testimony with comments from Scott Nago, Office of Elections. Welcome, sir. The floor is yours. Please proceed.
Thank you. The Office of Elections will stand on its written testimony providing comments and be happy to answer any questions.
Oh, I'm not going to let you go with just that. Scott, could you please summarize your testimony? Because everybody wants to know, what would it take for the state to conduct such a primary, and what are some of the issues that you're facing? Go ahead.
So, bottom line, it would cost just under $3 million for the state's portion of conducting the election. I do not know how much the counties would incur, what costs they would incur, but they would incur a cost because they would have to run voter service centers as well also. So we're looking at just under $3 million. Other considerations, I know there was an opt-out provision in the Senate version. Upon further consideration, I don't think we can do that because the state constitution says that you cannot, a voter can choose their political a voter chooses their political preference at the time of voting, not when they register. So if we do have opt-out provisions, we have no way of knowing which voters are members of which particular party, so we would still have to mail out ballots to all voters. So parties would not be able to opt out. And then we have various technical amendments that we are proposing.
And if you could just explain that, your office does not conduct closed primary elections. Political affiliation is not collected, nor is it a requirement to register to vote. Could you explain to people who are listening, what is a closed primary election as opposed to an open?
So we have open primary elections. A closed primary election would be when you register to vote, you register as a political party or register with a political affiliation, so that in a primary election, you can only vote in that political party, which is not what we have in Hawaii, where in Hawaii, in a primary election, you can vote any party, you just have to vote for all candidates in one party only. But you don't have to declare your political affiliation at the time of registering. You do it at the time of voting in the primary election.
And so if we were it's in your testimony as well, I want people to understand this. You were saying that you have to actually amend the Constitution to be able to accomplish what's laid out in this
That would
bill.
be our interpretation, yes. The Constitution does not allow us to conduct closed primaries.
Okay. I just want to make sure everyone understands. Because there's lots in your testimony that would have skipped had you not explained it. Thank you very much.
Thank you.
Okay, next we want to hear from let's go to Dennis Jung, Democratic Party of Hawaii. He's the state chairman.
Hello, everybody. Dennis Jung, Chair, Democratic Party of Hawaii. I wish to wish everybody a happy Friday to begin with, and I'd like to stand on my testimony subject to questions.
And your testimony in support.
Yes, absolutely.
Okay, thank you.
Thank you.
Next, we have testimony in support from the Legislative Committee of the Democratic Party of Hawaii. Next, we have testimony in opposition from the Stonewall Caucus of the Democratic Party of Hawaii. Michael Golyev. Please proceed.
Good afternoon again. Yes, the Stonewall Caucus is in opposition to this bill as it's currently stated. We are not going to belabor what's already in our testimony. Standing on our foundational documents, the Democratic Party is a strong believer in closed primary systems, and as has been already stated, we can't do a closed primary without first, the state can't do a closed primary without first amending the state constitution. Some of the other things we do want to bring everybody's attention to, that some people have been saying, it's only $2.7 million. That's just on the state side, and that's $650,000 a year. If you look at the GIAs that go unfulfilled every year, I'm sure that there are other well-meaning nonprofits that could actually use that money for better purposes than this. Because there is no guarantee or data that by doing this presidential election outside of the normal state-run primary election, that there would be any greater number of voters that show up than what is currently being done when the parties run it. Especially being held at a different time of year. As we saw when we went to all mail-in, there was a lot of time, money, and energy, not just by the state, but by the counties to educate the voters. So I believe $150,000 that appears in the state's elections testimony is really low, given what's going to be required to get the education out there for a nonpartisan look at this, to educate the voters to make sure that they knew about this election. So that being said, there is no direct benefit to the state for the state taking this on. The Democratic Party's foundational documents are quite clear on this. I will state that the SCC, which is the State Central Committee, which is the governing body for the Democratic Party of Hawaii, gave the chair, as well as the legislative committee, the authority to support this bill, but state our support for a closed primary system. And so that is why we're here today, to make sure that that message is loud and clear. So as the bill currently stands, we oppose it. Mahalo.
Thank you very much. Next we have testimony with comments from the Democratic Party of Hawaii Labor Caucus. Next we have testimony from Bart Dame.
Thank you, Chair, committee members. Yeah, my name is Bart Dame. I'm testifying as an individual, but I will confess up front I am the National Committee Man for the Democratic Party. But I also have a background in having worked on a number of presidential campaigns under the previous caucus system that we've used, and we've had good success doing that. However, the first presidential campaign that I worked in a serious way was Jesse Jackson's campaign in 1988. There was a total of just under 5,000 people voting all across the state and participating in that presidential caucus. That number jumped up when we had Hillary Clinton versus Barack Obama to 36,000 people. Some of you may remember the news stories of cafeterias with long lines going on, extending for hours. It was burdensome. It was difficult for us to provide the ballots for people. In the next time we had a big turnout was in 2016, where it was Bernie Sanders versus Hillary Clinton. Again, at that time it was about 35,000. And again, it stressed our abilities. This last time we opted to do an all mail-in system in order to make it more accessible for people who could not show up in person. That led to about 34,000 people participating. The amateurish way that we used to do it had a Frank Capra-esque kind of small town democracy feel to it, but it became unwieldy. And as someone who has been an official observer of elections and has given grief to the Office of Elections about the need for security, I feel very uncomfortable saying that the party should be able to conduct elections where we do not have the same ability to have safeguards for elections as the Office of Elections does. We don't have access to signatures, for example, to confirm signatures when we conduct all mail-in things. It's become too big for us to handle. If anyone wants to ask me a question, I will speak to the issue about closed primaries as well. Thank you.
Thank you very much. Next we have testimony and support from Steve Canales, Lorna Takehara Strand, testimony in opposition from Mike Goliath Sr., testimony in support from John Bickle, Lynn Otaguro, Larry Meacham, Leimomi Khan, testimony in opposition from Abby Simmons, Lynn Matusau, testimony in support from Betty Vega, Larry Smith, Amy Monk, Susan Young, Charles Ice, Richard Maderos, Elton Fukumoto, Deborah Ward, Lanny Sinkin, and Barbara Dalton. Is there anyone else here wishing to testify on HB 1485? Questions, members? Representative Iligan. Question.
Thank you, Chair. I want to ask a question to the Democratic Chair, Mr. Jung. My first question is, there are some concerns that I saw that you put on your testimony, and some of the opposition is saying that it's conflicting with your Constitution, and I think it's particularly having through having the Democratic Party of Hawaii believes that its primary election should actually be to ensure that the voters are through the membership of your party, with our party. So how is it that Article 1, Section 1, you're able to the party is able to testify in support, however, it's conflicting with the constitution of the party?
The short answer is simply that, our governor is elected through open primaries. Our lieutenant governor is elected through open primaries. Our state senators are elected through open primaries. Our members of the House of Representatives are elected through open primaries. Did you guys even imagine that you guys are elected in violation of the DPH Constitution? I understand what Mr. Galoya is saying, but quite frankly, there's a reality that that provision has been ignored for decades. We acknowledge that it would be really great if we had access to all the names of all the people who vote Democrat in the state of Hawaii, that if we could get our hands on all 300, 400, or 500,000 names, it would be beneficial to us. The reason that we are able to come out in support of the presidential primary is because we acknowledge at the State Central Committee that it is in the best interests of the people of Hawaii. If you think about Iowa, as I pointed out in my written testimony, how many of you remember over the years that we heard about ethanol? If you remember the arguments from decades gone past, that we need to have ethanol. And why do we need to have ethanol? Because it's derived from corn.
Please focus on the bill.
Yeah,
right.
You do mention that point regarding in your testimony.
Thank you.
Thank you about the open primaries. I just find it ironic that it's not through your leadership, but before we were criticized that we're not following the platform, and here we are not following the Constitution. But I'm not going to get there. I want to ask further questions about open primaries. I noticed that on the bill, you're wanting to do it in Fat Tuesday, and Second Tuesday in January. So exactly how would it be possible to maybe do it during the primary instead of having a separate time, and see if, and please tell me why that's not a possibility.
The presidential election conventions are held before the elections that come up in August of the year. And so essentially, to have an impact at all on who we elect as our primary candidate to serve in the general election, we have to get ahead of the presidential campaign that is handled nationally.
So you want to make sure that Hawaii is a player in the national field?
Yes.
Because currently right now we are, I'm guessing, not?
I seem to think that we are probably ignored. As I indicated in my testimony, that's pretty much the message I've gotten. But I've heard from the leadership of the DNC that they understand what we're going through in terms of trying to persuade our state legislature, and that I've been told that from the highest levels they are willing to work with us. They are sensitive to the fact that state legislators have obligations to the people. And so if they can amend their rules, they're willing to consider.
One last question. I was wondering, because elections had several amendments up to 12, and the companion bill already has those amendments. I was wondering if it's something that can you support the Senate bill instead of the House bill?
SB 1005 is wonderful. We definitely support that as well.
I have a question for the Mr. Nago.
Thank you.
Mr. Nago, I was hoping that we could possibly do it during the primary, but it doesn't look like that's an option, because the real intent is we want to be a player in the national side. So I was looking at your cost analysis. I know this was probably done in a rush way, but some of these things, maybe I'm just not sure, but it seems like they're a bit duplicative. And my example is like the ballot printing services. Are you doing it in-house or are you doing a third party? Why does it cost, why these costs are put down when you might possibly do it in-house?
So to answer your first question, we cannot hold this election with the primary election because the convention is before.
Yeah.
So it would make no sense to vote after the president or the nominee is already nominated. So in order to hold a presidential primary, you would have to have a standalone election, which would be all new ballots, all new envelopes. It wouldn't be duplicative because that's happening in August. So this is everything here. It's duplicative in the fact that you're doing it twice or 3 times, once for the special, once for the primary, and for the general. But you cannot combine them and say print ballots one time because you need to print it for the special. The primary election for the presidential, you need to print it for the regular primary election, you need to print it for the general election. So we don't see this as duplicative costs.
And these are the same staff that you would have. So are you doing it in-house or are you gonna?
No, we don't print ballots in-house. Ballots need to be printed under strict criteria by the voting system vendor.
Oh, okay.
Yeah, so it's not something you can just print in-house because otherwise you could take your ballot to a Xerox company.
My last question is, because you're dealing with a vendor that you already work with and you're gonna be doing bulk purchases, wouldn't it actually be, I know the cost, do you think the cost is gonna be a flat rate or is it more of a discounted rate with more purchases that you're gonna be making?
So these costs here, most of them are not for services. They're mainly consumables, like envelopes, like I said, ballots, postage. It's not something like, since they're gonna be here and already running the primary election, that they're not charging us double. These are consumables, and consumables can only be used once.
I see. Thank you.
Thank you very much. Any other questions, members? If not, thanks very much to the testifiers. Next, we'll move on to House Bill 264, relating to crimes against sports officials. Makes intentionally or knowingly causing bodily injury to a sports official a Class C felony. Authorizes a court to enjoin the offender from attending any sports event of the type at which the sports official was engaged in the lawful discharge of the sports official's duties. First up, we have testimony with comments from the Office of the Public Defender. Welcome. Thank you. The floor is yours. Please proceed.
Thank you. Good afternoon, Chair Tarnas, Vice Chair Takayama, members of the committee. My name is Lee Hayakawa from the Office of the Public Defender. The Office of the Public Defender has offered comments on HB 264, and we will be standing on our written testimony. I will be available for any questions.
Could you briefly summarize, because people don't always read your testimony, and the public would like to know what Public Defender's Office thinks about this bill?
Of course. The Office of the Public Defender has consistently opposed the creation of special classes to elevate, in this case, what would be otherwise a misdemeanor to a Class C felony or assault in the second degree. I mean, our position is pretty much, where will this end? And then it also, the legislature gets in the business of deciding what groups of people are more important or more valuable than other groups. And so that's the grounds of our opposition. But this year, we simply wanted to just make comment.
Okay, understood. Thank you very much. Next, we have testimony in support from the Department of Education. Welcome. Please come on up. The floor is yours. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, members of the committee. My name is Raymond Fujino on behalf of the Department of Education. We stand on our written testimony in support of this measure.
Thank you very much. Next, we have testimony in support from Parker Bodie, Honolulu Police. Not available. I refer you to his testimony. Next, we have testimony in support from the Hawaii State Basketball Officials Association. 2 individuals, Gabriel Jerez and Akira Usami. Next, we have testimony in support from Ariana McGurk. Please proceed.
Aloha Chairperson Tarnas, Vice Chairperson Takayama, and distinguished members of the Judicial and Hawaiian Affairs Committee. First, thank you for the opportunity to testify. My name is Ariana McGurk. I'm currently a junior at Kalaheo High School, and I'm in support of HB 264. I was born and raised on Oahu and identify as one of 40,000 high school student athletes in Hawaii. At the athletic events I've attended over the years, I've been a firsthand witness to acts of abuse towards sports officials. This abuse takes many forms, from verbal threatening to physical assault, before, during, or after a game. A survey by the National Association of Sports Officials reports that 87% of referees suffered verbal abuse in their role, and 13% said they had been subjected to physical assault. This calculates to 1 in 7 officials claiming some sort of abuse. Sadly, abuse is not limited to older officials. Youth that officiate sporting events can also be targets. And some young people, including a few of my friends, officiate sports part-time. However, this experience is often short-lived, with 80% of referees quitting within 2 years. In Hawaii, our pool of sports officials is rapidly declining because referees don't feel safe in their role. Without officials, there can be no sports, and it would be heartbreaking to see athletic events canceled, risking my peers' scholarship opportunities and taking away a popular extracurricular opportunity due to a lack of referees. I can attest as the athletic director assistant and student body president of my school that sports are critical to community building on campus. The implementation of this bill has the power to curb the decline of sports officials in Hawaii and therefore protect the future of sports at large. So thank you again for the opportunity to testify, and I hope you will help perpetuate our beloved sports culture in Hawaii and protect our people through your support of HB 264.
Thank you very much. Next we have testimony and support from Thomas Yoshida. Welcome. The floor is yours. Please proceed.
Good afternoon, Chair and Vice Chair and members of the committee. I'm Thomas Yoshida. I'm the president of the Hawaii State Basketball Officials Association, and I'm in support of this bill. I have provided written testimony for your review, but I'd like to reflect on a few things after listening to all of the commentary here today. It is very comforting to know that there is a cross-section in the community that supports us officials. As a 40-year basketball official, I have been threatened, I've been verbally abused, and I've actually been witness to an assault back in 2006 at Kalaheo High School. Unfortunately, my fellow official who was assaulted in that case, the victim was arrested, but no charges was ever placed on that person, even though I did testify as well as identify the perpetrator in that lineup. So it's comforting to know that both officials as well as students, as well as the Department of Education all support this. We feel that in the game of basketball or in any sports, there are two teams, the home team and the visiting team. But it's nice to know if they support this bill, the third team, the officiating team, will be supported. Thank you.
Thank you, Mr. Yoshida, and to all your members as well. Thank you. Next, we have testimony and support from Jasmine Ramos. Please proceed.
Aloha, my name is Jasmine Ramos and I am a senior at Kalaheo High School. I am in support of HB 264 and would like to ask you to be in support of this bill as well. The implementation of banning people from sports events after harming an individual should be in place already. Most people will get mad at refs in games and call out slander for their so-called bad calls, but these refs do not deserve the backlash, harm, and disrespect for doing their job. Those who officiate games and contests experience immense pressure while becoming knowledgeable and proficient at their job. Most often, officials get their jobs first with youth and recreational leagues as they progress toward higher levels of competition. To be injured in a league that should predominantly be for learning and fun causes many people to quit. I understand that a law may not be able to take place for these officials, but there are management practices that could be implemented. Some rules that could be implemented are early detection and ejection of unruly fans, development of well-publicized codes of conduct, strict enforcement of codes of conduct, better ways to address player frustration and anger through training and coaching, increased presence and action of security personnel, and developing policies and support of state laws to better educate people on the consequences of their actions in intimidating and abusing officials. As noted in a 2002 report by the National Association of Sport Officials, 18 states had enacted laws against this abuse, with many other states in the process of enacting legislation to prevent this problem. Regardless of state law, abuse of officials continues to occur, and this issue is a contributing factor to the declining numbers of qualified officials. If HB 264 is passed, I believe it will be helpful to Hawaii citizens. This bill will hopefully allow for people to be less violent because they know that their actions will result in consequences. Please vote to pass on this bill so that we can make Hawaii a safer place. Thank you for your time and consideration.
Thank you very much. Next, we have testimony and support from Carlos Santana, Mark Massey, Ryan Nakamine, Alton Mamiya, and Mike Ishikawa. Is there anyone else here or on Zoom wishing to testify on House Bill 264? Seeing none, questions, members? Representative Ganadin.
Office of the Public Defender. Hey, afternoon.
Hi.
Just to educate the committee and I guess those watching, if an individual is charged with, I guess this sort of elevated charge that would ordinarily be a misdemeanor, can it be what we would say like dealt down, down to a misdemeanor, and then maybe the court might issue a protective order stating that the defendant doesn't go to any more games or something like that? How might this work out?
Well, that call would be up to the prosecutors or whoever the charging agency is, whether it's the attorney generals or the county prosecutors. So I can't tell you exactly. I mean, it could happen. They could reduce it in some sort of plea bargain.
Okay. One more. Do you think that it's part of sports culture, whether good or bad, to dispute charges with referees? And it's some jobs it requires you to have kind of thicker skin. So would the things that oftentimes happen at games, calling a referee blind or stupid or missing a bad call and raising your voice at them, would that lead to individuals being charged with C felonies?
I think there's a freedom of speech issue in there. But make no mistake, the Office of the Public Defender doesn't condone violence against, athletic officials. But
I guess what I'm saying is I'm worried about the ordinary behavior that happens at games, good or bad, turning into increased charges, terroristic threatening, coach getting into a chest-bumping match with a home plate umpire turning into a C felony. Could something like that happen here?
I think potentially yes. Assault, simple assault in this state is defined as intentionally, knowingly, or recklessly causing bodily injury. Bodily injury can be as little as pain, so it doesn't have to be a black eye or anything major. It can be as little as pain. So theoretically, in any of those instances, there could be criminal charges, yes.
Thank you.
Thank you. Thanks very much for that line of questioning. Any other questions, members? If not, we'll move on. Thanks to the testifiers. Next, we have House Bill 364. We just came from 264. Now we're moving on to House Bill 364, relating to trespass. Clarifies that when trespass involves public land, all state and county law enforcement officers are authorized to and shall enforce trespass laws without regard to whether the land is owned by the state or by the county. On this measure, we have testimony and support from the Hawaii State Public Library System, Stacy Aldrich, State Librarian. We also have testimony and support from the University of Hawaii, Calbert Young. Testimony in opposition from Baron Chun and Cheryl B. Is there anyone else here wishing to testify in House Bill 364? If not, questions, members? Nope, we'll move on. House Bill 1231, relating to criminal property damage. It amends the misdemeanor offense of criminal property damage in the third degree to include intentionally or knowingly damaging the property of another that is used in a business operation without the other's consent. On this measure, we have testimony in opposition from the Office of the Public Defender. Welcome. floor is yours. Please proceed.
Thank you, Chair and Vice Chair, members of the committee. My name is William Bento. I'm a Deputy Public Defender. The office does not object to the desire of the bill to protect businesses, especially small businesses. We do understand that things can become disruptive. And even, the pandemic taught us that, especially for small businesses, 1 or 2 days of not being able to work can be very difficult. But the bill, the way it's written, is very broad. And so as I gave 2 examples in our testimony, very minor things could be charged as a full misdemeanor that would usually be considered a petty misdemeanor. We did suggest amending language that would make this type of activity or this type of offense a misdemeanor if the business was actually disrupted. And we think that that's what meets the goal of what the bill intends to do. And so we would ask to have the committee strongly consider that language. And I'm available for questioning. Thank you.
Thank you very much. Next, we have testimony and support from Michael Kitchens and Bonnie Fujita. Is there anyone else here wishing to testify on House Bill 1231? If not, questions, members? Seeing none, we'll move on. Thank you very much. Actually, let me ask a question of Mr. Bento. If we were to, I appreciate your recommended amendment, but as a way to even make it more clear, could we perhaps put a dollar amount of damage, like $100, so that it's much clearer that that would be the trigger, that would be the threshold?
Well, you could. I think you have the authority to do that, but the threshold is already there between a petty misdemeanor and a misdemeanor, so you would be kind of going in between.
What is the threshold is 500?
Right. So if you wanted to do it for a $100 bit of damage, but it's for a business, and that would trigger it, making it a misdemeanor, you would certainly have the authority to do that as well. And it could be clearer than whether that disrupts the normal operations of the business.
Okay, thank you. Thanks very much. Any other questions, members? If not, we'll move on. Next bill, House Bill 1325, relating to wrongful convictions, sets forth requirements under which a convicted person may seek review for a criminal conviction. First up, we have testimony with comments from the judiciary. Welcome, the floor is yours. Please proceed.
Good afternoon, Chair Tarnish, Vice Chair Takayama, and committee members. Thomas Berger, I'm a staff attorney at the Hawaii Supreme Court. The judiciary would request that the measure be deferred. The judiciary is prepared to present this bill to the Hawaii Supreme Court's Criminal Rules Committee. That committee is made up of representatives from the Department of the Attorney General, the Office of the Public Defender, prosecuting attorneys of each county, and private attorneys from the Criminal Defense Bar. It's also made up of judges from each circuit. So we'd ask the measure be deferred to allow these subject matter experts to review the bill and to consider it for possible rule amendment. Thank you.
And your rule amendment, just so people who are listening understand, this is you referred to it, the Hawaii Rules of Penal Procedure?
That's correct, and it's Rule 40.
Rule 40 within that, okay. And that's the rule under which a prisoner may petition to set aside a conviction based on newly discovered evidence or any ground which is a basis for collateral attack on the judgment.
Yes, sure, that's correct.
Okay, just want to make sure that those who are listening understand.
Okay.
Okay, thank you very much.
You.
Next we have testimony from the Attorney General. Welcome. The floor is yours. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, members of the committee. My name is Deputy Attorney General Albert Cook, and the department believes that this bill is unnecessary as the post-conviction relief mentioned by the judiciary proposed in this bill is already adequately covered by Hawaii Rules of Penal Procedure Rule 40. This bill proposes creating a new post-conviction procedure and would allow petitions for release to be filed upon 4 different conditions that are laid out in the bill. Subsections B1 through 3 while we believe they contain some problematic language that's vague and has undefined terms, would largely fall under HRPP Rule 40, subsection 1, A14, which allows for post-conviction hearings upon presentation of new evidence. Subsection B4, allowing a post-conviction hearing anytime there is a significant dispute about expert testimony or science, would necessitate a hearing, we believe, in almost any case, as there's always a significant dispute on expert testimony. And that's why each side provides their own experts at trial, and an independent fact finder decides which expert is more credible. So we believe this subsection is unnecessary and problematic. So our testimony more fills it out in more detail, but as HRPP Rule 40 sufficiently provides for legitimate post-conviction relief, the department asks that this bill be held. Thank you.
Thank you very much. Next, we have testimony from the Department of the Prosecuting Attorney, Tricia Nakamatsu. Welcome. The floor is yours. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, Vice Speaker, members of the committee, Deputy Prosecutor Tricia Nakamatsu, appearing on behalf of the Honolulu Prosecuting Attorney's Department. We are in opposition to the bill, and our comments generally echo that of the Attorney General's. We feel that Rule 40 adequately covers all of the subject matters that are raised in this bill, all the bases, and our testimony, the written testimony you have before you, we feel highlights the most salient parts, which allow at any time for anyone to seek relief from the judgment of conviction on 5 enumerated bases, one of which is newly discovered evidence, and the other, which is like a catch-all omnibus clause, any grounds which is a basis for collateral attack on the judgment. And on these bases, we feel that there are numerous Rule 40 petitions filed every year, which are duly considered. There's a well-established process that's been in development for over 40 years. There's case law, there's precedent, and we feel that all of the new language that's being proposed here, as well as different mechanisms, different language, would only serve to confuse and add further unnecessary litigation that is already covered.
Thank you very much. And finally, we have testimony from Kenneth Lawson, the Hawaii Innocence Project. Please proceed.
Thank you. Real quick, I kind of like what the Hawaii Supreme Court recommended. I do think, I hope, I'm testifying in support of the bill, and I think, the position from the prosecutor's office and the attorney general's office, I respect. But what the bill does, you don't know what you don't know, right? And so what the bill does, it highlights scientific evidence that isn't scientific evidence. It highlights evidence that has been put into court, such as bite mark testimony. All this expert testimony that has come out over the last couple of, about the last 15 years, as being invalid forensic science. And so unless a lawyer is up to date on bite mark evidence being no longer valid science, on microscopic hair analysis, where hair is found on the victim's body, and then they take one from the suspect's head and they put it underneath a microscope and they say, hey, this is a match. That is invalid science. And so what this bill does, it focuses the attorneys on, you have to be alert to new evidence in the scientific area, because we are learning over the last 15 years, there's a lot of convictions that have happened based on supposedly expert testimony that has just been bogus science. And so what we see on CSI is just not true. The only valid science is DNA, period. And so I kind of like what the Supreme Court, if you're not going to vote the bill up, at least defer it so that the court can at least examine this issue, because, again, the attorneys have to become more educated. I don't want to put no more work on attorneys, but they have to become more educated. Judges have to learn about this area. And I think that we can help, we being the Hawaii Innocence Project can help educate in this very, very vital, important area. Thank you.
Thank you very much. And for those who don't know, the Hawaii Innocence Project is a nonprofit legal clinic that is associated with the William S. Richardson School of Law. And I appreciate you being here, Professor Lawson, to speak to us today. Is there anyone else wishing to speak on House Bill 1325? If not, questions, members? Representative Souza, please proceed.
I have a question for Ken Lawson.
Yes.
Just a disclosure, I did work on the Schweitzer case back when I was in law school with Ken and Ginny Henge and everyone involved in that. So thank you for persisting with the case. Just, can you explain and just clarify further how Rule 40 was deficient in this scenario with the Schweitzer case, and how maybe we do need something in the statute or a revisit of HRPP Rule 40 to basically clarify, because it appears that you guys had some problems either getting the case heard again or whatnot based on Rule 40. So can you kind of explain that?
Well, and so in the innocence practice, right, underneath Rule 40, you have to come up with newly discovered evidence. But there's case law in the Seventh Circuit that talks about if you have evidence that may not have been newly discovered but was never presented, then if it goes towards actual innocence, you can present that evidence also in a habeas petition or Rule 40 petition. It's not so much that the Rule 40 failed us. I think what the prosecutor and the AG are saying is correct, but I think what's being missed is the importance on the changes in scientific evidence and what's admissible and what's not. And lawyers, no one has time to understand the changes in DNA, the changes in microscopic hair analysis, all the other changes, shaken baby syndrome, right? People think that that's actually true science. I don't want to get into all these debates. And so what this bill does, and what I like about it, is that it makes the lawyers focus on, look, this is an area to where you can have newly discovered evidence depending on the science changing. And you better be on top of it, because not to be means that, one, an innocent person can stay in prison, and two, you may be engaged in malpractice because you have to stay on top of this type of stuff. And so what we have been trying to do is educate. We put on seminars, we bring in people from across the United States who are experts in these areas and open it up for free to the community, legal community, and try to do a CLE to educate individuals on this, because again, you don't know what you don't know. And so that's why I like what the Hawaii, at least what the Supreme Court said, is that they understand why it's important to put into the Rule 40. They just want to study it.
Great. Thank you so much for clarifying.
Thank you very much. And just for those who don't know, CLE, that the professor referred to, is a continuing legal education. Even attorneys need continuing education.
Yeah, I just did mine. Yeah.
And Representative Ganadin said he just did his, so. Okay, any other questions? If not, we'll move on to the next. Oh, Representative Ganadin, please, go ahead.
To Mr. Berger with the staff attorney with the Hawaii Supreme Court. In your testimony, I don't see, let's see, can you explain how the modification of HRPP Rule 40 might incorporate the desire of this committee and the introducer in amending the rule to allow for this this evidence based on science?
Thank you for the question, Representative. I think that's something that I would leave for the Rules Committee. They're the subject matter experts in this area. You know, the bill touches on criminal law, and that's something that to have the input from the Public Defender's Office, from the prosecutors who practice in the area, from the judges who see this on a regular basis. I think that that's important. So I would defer to the committee on that.
How long would that committee process take? And can you explain to the committee what that process looks like?
Well, you know, the judiciary often gets requests from the public to evaluate rule changes. So I think it's going to depend on the availability of the committee members. But if I can recall, the last time that there was a rule change, it can happen pretty quick over the course of a few months. The rule then does go out for publication, and the public has an opportunity to comment on it. So it doesn't just get put into effect. And there is about, I think, a few months there as well. So hopefully before the next session, we can have an answer.
Thank you.
Thank you very much. Any other questions, members? Now we'll move on. Thanks to the testifiers. Next, we have House Bill 1440 relating to the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. It adopts the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act and repeals the superseded act. First up, we have testimony from Robert Mark Browning, the Judiciary. Next, we have testimony from Margaret Leong, Deputy Attorney General. Welcome. The floor is yours. Please proceed.
Thank you. Thank you, Chair, Vice Chair, and members of the committee. Margaret Leong, Deputy Attorney General. Excuse me, the department has offered comments regarding some recommended review that we recommend in light of looking at this provision as it is, excuse me, and comparing it to additional laws that need to be considered as this provision goes forward. We've highlighted several of them, including but not limited to the issue of juries, the jurisdiction of family court. There's some language regarding domestic partnership that should be reviewed or considered under Chapter 572B HRS having to do with civil unions. Just definitions in return necessary for shared household responsibilities and recommendations for that. Consideration of a referral of an order, excuse me, that appoints a conservator or guardian, the referral of that order to the Hawaii Criminal Justice Data Center, as currently is under 560 right now. I will be here for any questions that you may have, but we thank you for this opportunity to comment.
Thank you very much. And just for folks listening, the judiciary is not here, but they are respectfully suggesting that a detailed and comprehensive review and assessment of a range of stakeholders should be undertaken prior to the implementation of such a fundamental change in the existing statutory framework. This review and assessment will take time. It will require the judiciary to develop and implement significant new operational processes and will require substantial additional resources. So they're requesting that the bill be deferred to allow this process to go forward. The stakeholders can work together and figure out a best path forward. Next, we have testimony from Kathy Betts, Department of Human Services, or a representative.
Good afternoon. Again, Tim Hitchens, Social Services Division Assistant Administrator for Director Betts in the Department of Human Services. Our concerns are similar to those you heard from the Attorney General and the Judiciary, that this is a pretty big change. There's a lot of moving components, and we would request a bit more time to analyze and see what that would look like. Also, just one point of clarification on page 9, lines 3 to 5 refers to Hawaii Revised Statutes, Chapter 583A, Title or Article 5, and I don't believe there's an Article 5 there, so we just didn't know what that was intended to be. Thank you.
Thank you very much. Next, we have testimony from Elizabeth Kent.
Aloha. I'm one of Hawaii's Uniform Law Commissioners, and I'm here to testify in support of this. I also want to say I'm glad that Ben Orzeski, the Chief Counsel for the Uniform Law Commission, is here, and he's a wonderful resource. And I heard the testimony in which you talked about. I would welcome meeting with other stakeholders during the interim to work out some of the issues so that we can move forward with this. Thank you.
Thank you. Thank you very much, Ms. Kent. Next, we have testimony from Daintry Bartoldas, the State Council on Developmental Disabilities, or representative.
Chair, Vice Chair, committee members, my name is Chase Silver with the Hawaii State Council on Developmental Disabilities, representing Daintry Bartoldas. We did provide written testimony, and we will stand on that testimony, but we just wanted to add why a measure like this is important to our population, specifically people with developmental disabilities. One thing is that it does remove language like incapacitated persons, which you have to be labeled to have a guardian. It does fix a issue right now with our state where it's actually easier to get full guardianship rather than get limited guardianship. So it's easier to remove more rights away from somebody than it is to keep them with some. It also fixes a bunch of different various issues, as we do have an older, antiquated guardianship law currently, and it does give more guidance to guardians as well as the person's paperwork and stuff like that follow up. Thank you so much. We're here for questions as well.
Thank you very much for that summary. Next, we have testimony from the Uniform Law Commission. Benjamin Orzeski, please proceed.
Hello, thank you, Chairman Tarnas, Vice Chair Takayama, and members of the committee. I'm Ben Orzeski, Chief Counsel from the Uniform Law Commission, and I'm here today on behalf of, at the request of the Hawaii Uniform Law Commissioners. Hawaii's current guardianship law is based on an older uniform law. Law that was approved about 25 years ago. And since then, there have been a lot of developments in this area of the law that were incorporated into an update of the Uniform Guardianship Act. And it's that newer version that is incorporated into this bill, HB 1440. There are many improvements that recognize the trends in guardianship law towards making sure that people who are subject to guardianship retain all of the rights that they are entitled to, that they're capable of handling, that they, especially the adults under guardianship, still have some free choice in areas of their life. So in a full guardianship, it's often compared to a parent-child relationship. And for an adult, that's not really appropriate. And this new updated Uniform Act would ensure that each guardianship proceeding involves an individual assessment of the person's abilities and needs before any guardianship order could go forth, and it would require the courts to impose the least restrictive alternative that's possible in order to ensure good care for the person who's the subject of the hearing. So it seems that this law is likely to be deferred. I want to say that the Uniform Law Commission will assist. We have a lot of resources from studying this area. The uniform law was drafted by guardianship experts from across the country, and we'll be happy to contribute in any way we can to the upcoming study. Thank you.
Thank you very much, sir. Appreciate you staying up late to participate.
Glad to.
Next, we have testimony and support from Keali'i Lopez, State Director of the American Association of Retired Persons. Please proceed.
Aloha, Chair Tarnas, Vice Chair Takayama, and committee members. Keali'i Lopez with ARP Hawaii. ARP stands in support, strong support of HB 1440, which adopts the Uniform Guardianship and Conservatorship and Other Protective Arrangements Act. Our concern really is that, as indicated by Ben and others, that our guardianship laws need to be updated. The concern we have is really the ability to have the guardianship programs have greatest protection for the individual who is subject to guardianship, and that includes ensuring that they have the least restrictive ability to engage with their guardian or a representative that has the least impact on their independence. So from our perspective, more guidance for guardians and conservators, many of whom are family caregivers without any training for the role. The new law also, proposed law, provides greater protection for those subject to the guardianship, ensuring they have access to friends and family and are not isolated from their support community. It also contains a brand new provision that I indicated is less restrictive in the protective arrangements. It allows the courts to address the respondent's problems without taking away their rights. I just want to add a few more points, and that is that the guardianship laws does need to be strengthened, and we want to make sure that the rights of our seniors aren't really in a one-size-fit-all cookie-cutter approach, that there's consideration for the differences and the different types of guardianship that are required. And importantly, we want to ensure, as I indicated earlier, that judges explore other options for appointing a guardian and make guardianship a last resort. We look forward to the work. I'm happy to hear that the judiciary and the Department of Human Services are interested and willing to work on this. Just hope it's something that we can get to for this next legislative session. Would hate to have us come back to you, Chair Tarnas, and ask for a task force and drag this out yet another year. So eager to work with folks to make sure we can have something more current available to the people of Hawaii a lot sooner.
Thank you.
Aloha.
Aloha. And next we have testimony from John Pollack as well. Is there anyone else wishing to testify on HB 1440? If not, questions? Representative Iligan.
Thank you, Chair. I had a question for the representative over Department of Human Services. My question is, it seems like most of the stakeholders are supportive and sees many benefits of this moving forward and being updated. Is there, I mean, I read through your testimony and I didn't see, I was just wondering, wouldn't it be better to pass it out and take that bold action and then fine tune it afterwards?
I wouldn't necessarily oppose that approach. We just still have a bit of discovering left in our review of it. There's a bit too. We want to crosswalk with some other laws, see if there'd be anything as far as appropriations necessary to carry everything out properly. It completely makes sense in the whole least restrictive environment. You know, that's among the things that we support. We're just not ready to say exactly, you know, respond to that yet.
And when you do run across the lack of appropriation, I'm sure that that's not gonna move forward, and then the changes could be either repealed or we find the appropriation at another time. Wouldn't that be some of the, I'm trying to understand what is the major holdup it would, other than requiring that time?
Sure. Let me grab my papers because I do have one section that might be helpful.
Yeah, please.
A moment. So in one instance, we do petition the court frequently for guardianship, emergency guardianship, and conservatorship, as well as, I was trying to find the other section, but we go through this process quite a lot in adult protective services, and so it's going to have an impact whether we're going for a higher level of evaluation or if we have to identify providers who can provide another level of evaluation. So that change is going to require a little bit of exploration still. There's training involved with our staff to make sure they understand the different levels that are becoming available or would become available with this bill. So again, not anything specifically that we would oppose. It's just going to take a bit of time to implement things like training, potentials for funding, gathering and collecting and sort of identifying resources that we might need in addition with some of the processes that are in place.
Thank you. Yeah, that's what's on your testimony. Thank you.
Is that helpful? Okay. All right. Thank you.
Thank you very much. Any other questions, members? If not, thanks very much to the testifiers. We'll move on to the next bill, House Bill 913, relating to the Natural Energy Laboratory of Hawaii Authority. Amends the statutory duties of the Natural Energy Laboratory of Hawaii Authority, requires the authority to conduct certain activities in a culturally sensitive and environmentally appropriate manner, and to engage in community outreach and education. First up, we have testimony from the University of Hawaii with comments. Nope, not on Zoom right now. I refer members to the testimony from Mr. Sirmos. Next, we have testimony from the Natural Energy Laboratory of Hawaii Authority, Mr. Greg Barber. The floor is yours. Please proceed. Thank you for your patience.
Thank you. Thank you, Chair Tarnas and Vice Chair Takayama, members of the committee. I'm Greg Barber, Executive Director of the Natural Energy Lab in Kona. And we thank you for hearing this measure. And we have comments. We'll stand on them. I do want to make a couple clarifications. One is, you know, we believe we are successfully meeting the objectives of this measure at this time, and we support it in that regard. However, on page 2, line 2 of the measure, it indicates that we need to be in compliance with all county laws and regulations. Currently, all state agencies and public projects are immune from county planning and zoning regulations per AG opinion. So this would make us one of the only state agencies that need to conform or not immune from these regulations. Alternatives would be to delete the word county, or we believe this measure is really related to animal welfare. So on line 4, I believe the word requirements, we could add the language as it relates, the requirements as it relates to animal welfare that would be acceptable to us. The other issue is that all of our research proposals would be required to be reviewed by the, I'll just say the acronym IACUC.
I'm going to call it the Institutional Animal Care and Use Committee
of the University of Hawaii. And this is a scientific issue that Chair Tarmas could probably explain better than I, but currently the National Institute for Health develops these protocols for determining animal welfare, and they only relate to vertebrates. Most of the animals...
That's with a backbone.
With a backbone. Thank you. So most of the research projects at our facility are invertebrates.
Without a backbone.
Without a backbone. So mollusks.
Clams, oysters.
And crustaceans are invertebrates.
Crabs, lobsters. Thank you, sir.
So it's a complicated issue, but in short, the University of Hawaii has no protocols for determining animal welfare for invertebrates. So it gets complicated quickly. Thank you very much.
Thank you very much, sir. Thanks for traveling over here. Next, we have testimony in opposition from Neil Sims with Ocean Era and testimony in support from Dana Kiave. Is there anyone here or on Zoom wishing to testify on HB 913? If not, questions, members? One question from Representative Ilagan. He's got a quiver of questions, but I'll ask him just to ask one.
Sir, I was just wondering, can't you already do all this? Like, why do you need to codify it?
I think there's some members of the community that feel that some of the animal welfare issues, as they refer to cephalopods, are not
octopus
are not appropriate.
Thank you.
Thank you.
Thank you very much. Any other questions, members? If not, we'll move on. HB 522, relating to emergency management, removes the ability of the governor or mayor to suspend electronic media transmission during a state of emergency. First up, we have testimony in opposition from HIEMA, the Hawaii Emergency Management Agency. Please proceed.
Thank you, Mr. Chair. Members of the committee, appreciate the opportunity to testify. We stand on our testimony in opposition as stated in the previous hearing. While we recognize the concern raised by the proponents of this bill about overreach, their proposed solution to simply strike the end of the clause in question may be removing some flexibility that is useful in responding to certain types of emergencies. We've added some language to this testimony to indicate that we are willing to work with the proponents of this bill to try and find a solution that meets their concerns while still maintaining the flexibility of emergency response that's intended by 127A. Thank you, and I remain available if the committee has questions.
Thank you very much. Next, we have testimony in support from Hawaii County Council, testimony in support from the Hawaii Association of Broadcasters. Thank you for your patience. The floor is yours. Please proceed.
Thank you. Good afternoon, Chairman Tarnas, Vice Chair Takayama, and committee members. My name is Chris Leonard, and I'm the president of the Hawaii Association of Broadcasters, a trade organization that represents about 100 radio and television stations across the state. I'm also the president of New West Broadcasting, which owns and operates radio stations on the Big Island, as well as serving as the chairman of the Hawaii State Emergency Communications Committee and as a member of our local emergency planning committee in Hawaii County. I have over 30 years of experience with emergency management communications and significant knowledge of the technical systems and equipment used to provide that communication. We strongly support HB 522 as it addresses a threat to public safety and fixes an unconstitutional provision in Hawaii Revised Statutes 127A. Under current law, the 127A grants unnecessary and unconstitutional additional powers that pose a threat to public safety. The current language states that a governor or mayors may shut off water mains, gas mains, electrical power connections, and to the extent permitted by or under federal law, suspend electronic media transmission. Electrical service we get during a hurricane, you have down power lines, you turn off the power because down power lines pose a threat to life and safety. Same thing with gas mains. If you have a earthquake and you have a gas main rupture, you turn it off so they don't explode. I'm not sure what turning off our radio and television stations are going to protect us against. The provision, the current statute has a number of different issues with it. I'll highlight a few here. We believe that it's clearly an unconstitutional prior restraint. Prior restraints have been resoundingly rejected by the Supreme Court historically. There's jurisdictional issues with the law. It says that to the extent permissible under federal law, we're unaware of any federal law that grants this authority, and nobody's been able to provide support for that. And it leaves it up to the administration's interpretation of what's permissible under federal law. So if they were to shut us down, we could litigate it, but that takes time, resources, and money, and in the meantime, takes the public out of vital communication that's necessary in that period of time. And that's our concern. The language grants a
blank... If you
could
summarize, it'd be great.
The language grants a blank check to shut down electronic media transmission without providing for why this would be necessary, what systems, for how long, and how that determination would be made. And that includes potentially radio, television, internet, cable, cell service, text, etc. It's a problem. HB 522 addresses that issue in a very simple manner, and we strongly support the measure.
Thank you very much. Appreciate it. We can tell that you are a professional radio broadcaster because we all heard you. Excellent articulation. You project very well. Everyone should listen and follow your example. Okay, following up, we have testimony from Bruce Nakamura. Testimony in support from Brian Black, Civil Beat Law Center for the Public Interest. Testimony in support from KITV4 Island Television, Hawaii News Now, Hawaii Chapter Society of Professional Journalists. Testimony with comments from Grassroots Institute of Hawaii. Testimony in support from the League of Women Voters of Hawaii. All Hawaii News, Big Island Press Club. Testimony in support from Ryan Ozawa, and in opposition from Victor Ramos. Is there anyone else here wishing to testify on this measure? Seeing none, questions, members? Seeing none, we'll move on. Thank you very much. Okay, final measure is House Bill 1266 relating to food donations. Allows wild game to be donated as food. First up, we have Yuki Sugimura, Brian Miyamoto. Thanks for your patience, Mr. Miyamoto. The floor is yours.
Good evening, Chair Tarnas, Vice Chair Takayama, Vice Speaker Iligan, members of the committee. Brian Miyamoto here on behalf of the Hawaii Farm Bureau. You had some very complex and important legal issues in front of you today. We hope this is one of the easier ones. You have a written testimony in support. We believe this bill is trying to address two issues: invasive species and food insecurity. We're asking if wild game, which would include axis deer, the problem that we're having in Maui County on Maui Island and Molokai Island, and feral pigs, which we're having across the state, which are not just affecting our critical habitats, our fragile ecosystems, but agriculture now our health and safety concerns as they're coming closer to the urban core. So what we want is to allow the liability provisions as in Chapter 145D to be applied to wild game. And again, we don't want to waste that protein. We want it to be able to be donated to places like the Hawaii Food Bank and many of these nonprofit feeding programs that are helping our neighbors in need. So we appreciate you hearing this measure, Chair, and thank the committee, and we urge the passing of this bill. Thank you for the opportunity to testify.
Thank you very much. Next, we have testimony from Nicole Galase, Hawaii Cattlemen's Council, from Yoshito Lot with the Aina Ho'okupu o Kilauea, testimony and support from Hawaii Farmers Union United, testimony and support from Maui County Farm Bureau, and testimony and support from several individuals, Jimmy Gomes, Micah Richards, Frederick Mencher, Byron Kaneshiro, and Randy Cabral. Is there anyone else here wishing to testify on House Bill 1266? If not, questions, members? Representative Ganadin, please proceed.
I'll try and be quick. Mr. Sugimura? I'm sorry, did I get that right? Oh, I got
Miyamoto.
Miyamoto, I'm so sorry.
Brian Miyamoto, Hawaii Farm Bureau.
Hawaii Farm Bureau. It's been a long week. I'm sorry, I'm not totally up on Section 145D. Does this preclude a hunter from basically culling wild animals and then selling them for profit? Or do they have to donate? How does that process work?
Brian Miyamoto here on behalf of the Hawaii Farm Bureau. Thank you, Representative Ganadin. A hunter or anyone that wants to sell some like axis deer, it's same as cattle, it needs federal inspection, it needs USDA inspection. If they're giving it away, they can do whatever they want with it. What we're seeking for in this bill is that liability provision that's afforded in Chapter 145D. So for wild game, again, a hunter can give it away. They can choose to sell it commercially, but they do have to get it federally inspected. So there are some other bills that are alive in the legislature that's seeking to increase the inspection capacity here in Hawaii. Right now, we only have federal inspectors. We still have a Hawaii mean inspection, which would make it easier, I believe, for wild game. For example, if you're slaughtering cattle, USDA pays for that inspection. For axis deer, Maui Nui, it's a voluntary inspection, so they still need it inspected if they want to sell it commercially, but they have to pay for the inspection.
Okay. Thank you. And those bills are still alive that would encourage the reduction of axis deer population and like say feral pig population?
Yes, Representative. There's a kind of a few bills that are trying to address that issue, and it's basically the axis deer and the feral pig issues that we're having. We're just trying to reduce those populations. We're not trying to eliminate. We want the hunters to be able to continue to hunt. But if you are not from Maui or Molokai, I don't think you can really appreciate, even myself, how bad it is on those islands. And then feral pigs, every county has feral pig problems. We just visited some ranches on Hawai'i Island, and everyone is dealing with feral pigs, and they're coming further and further to the urban core. And these are very dangerous wild animals. So we want to take advantage of reducing the population, but putting the proteins to good use.
Thank you.
Thank you very much. Any other questions, members? If not, thank you very much.
Thank you, Chair.
Yep. Thank you to all the testifiers on our measures today. That completes all of our public hearing and testimony on these measures. With all members here, I'd like to move forward into decision making. Back to the top of the agenda, House Bill 581. I recommend we move this out with amendments, so it's a House Draft 2. I would like to adopt the amendments offered by the judiciary on page 3 of their testimony, which I read out during our hearing, and make some technical amendments as well. With that, are there questions or concerns, members? And I want to let folks know I did get the prior concurrence from the chair of the first committee, Human Services, who is serving on our committee today. With that, if there's no questions or concerns, Vice Chair for the vote for an HD2.
Voting on House Bill 581 HD1 with further amendments, Chair and Vice Chair vote aye. Representative Ganadin. Representative Holt. Excused. Representative Hashimoto.
Aye.
Representative Ichiyama.
Aye.
Representative Ilagan.
Aye.
Representative Kong.
Aye.
Representative Mizuno.
Aye.
Representative Souza.
Aye.
Your recommendation is adopted.
Thank you. Next, moving on to House Bill 448, I would like to adopt the recommended amendments from the Hawaii State Coalition Against Domestic Violence, deleting lines 3 to 18 on page 3, and instead include the following language: that any minor 16 years of age or older on their own behalf without the consent of a parent or legal guardian, or any emancipated minor as defined in section 577-25 Hawaii Revised Statutes. With that change, I would like to move out House Draft 2. Questions or concerns, members? And I also did get prior concurrence from Human Services Chair as well. Thank you very much for that. If there's no questions or concerns, Vice Chair for the vote.
Voting on House Bill 448 HD1 with further amendments, noting the excused absence of Representative Holt and all other members being present. Anyone wishing to vote WR or no? Seeing none, your recommendation is adopted.
Thank you very much. Next, I would like to move on to 470 relating to minors. On this one, I would like to recommend making some amendments to it. In particular, adopting the amendments as recommended in the Department of Human Services testimony on page 2, where we're adding a provision that they identified and we discussed during our testimony. With that, I would like to pass out an HD2, House Draft 2. Questions or concerns, members? And I did get the prior concurrence from Human Services Chair. No questions or concerns, Vice Chair for the vote.
Voting on House Bill 470 HD1 with further amendments, noting the excused absence of Representative Holt. Anyone wishing to vote WR or no? Seeing none, your recommendation is adopted.
Thank you very much. Next, we're moving on to House Bill 650. This is a very important measure. I appreciate all the testimony on this. Very compelling motivation to advance this bill. I would like to move this out with the House Draft 2, merely by changing the effective date so that it's clean. It'd be effective upon approval. I did get the prior concurrence of the Health Committee Chair. Somebody needs to answer their phone. Any questions or concerns, members? Yes, Representative Ganadin.
Just my appreciation to the chair and the committee members for the maturity in this conversation. I think this is a human rights issue, you know, choosing how you wish to die, essentially, and paying attention to best practices, and especially this conversation that we had about waiting period. I thought it was really mature, and we attempted to honor these people's wishes. Thanks.
Thank you very much. Yes, it's a very serious matter, and we have to treat it with respect. Any other questions, members? If not, recommendation to move out of House Draft 2 with a clean effective date. Vice Chair for the vote.
Voting on House Bill 650 HD1 with further amendments, noting the excused absence of Representative Holt. Anyone wishing to vote WR or no? Representative Kong?
No vote, thank you.
A no vote registered for Representative Kong. Chair, your recommendation is adopted.
Thank you very much. Next, we have House Bill 642. On this measure, I would like to recommend moving out an amended version, so it would be a House Draft 2. And I would like to take the recommendation of Department of Commerce and Consumer Affairs, Division of Financial Institutions, and apply the exemption to Part 2 as well. So financial services organizations would not be covered by this because they already are covered by other state and federal requirements to report. I did get the prior concurrence of the chair of the Consumer Protection Committee. I still want to keep the defective effective date, but move it out with that one change, exempting financial institutions. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 642 HD1 with further amendments, noting the excused absence of Representative Holt. Anyone wishing to vote WR or no? Seeing none, your recommendation is adopted.
Thank you. Next, House Bill 899, relating to health. I think everyone is in agreement on this measure. I'd like to recommend changing the effective date so it's effective upon approval and passing it out. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 899 HD1 with further amendments, noting the excused absence of Representative Holt. Anyone wishing to vote WR or no? Chair, your recommendation is adopted.
Thank you very much. Next, on House Bill 1485, relating to the election of the President. As was discussed in our hearing and in questions in the testimony, there is a need, if we're going to do this, for funding of $2.7 million in order for the state to run such a primary. This measure has no appropriations in it. If we were to add appropriations to it, it would be re-referred to finance and it would not be able to proceed because we passed the lateral deadline. So my recommendation is to defer this measure and wait for Senate Bill 1005. If it does pass the Senate, it does have request for finance, for appropriations in there. It's now currently being considered by Senate Ways and Means Committee. So that's my recommendation, defer House Bill 1485. Next, let's move on to House Bill 264. On this measure, I really acknowledge the hard work of sports officials throughout the state. They enable many of our citizens to participate in sports, and I would like to make sure that they're well protected. So I acknowledge what the public defender said, but I would still think that this is worth moving forward. And so my recommendation is to approve this as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 264, passing as is, noting the excused absence of Representative Holt. Anyone wishing to vote WR or reservations for Representative Ganadin? Chair, your recommendation is adopted.
Thank you very much. Next, let's talk about House Bill 364, relating to trespass. I think everyone, all the testifiers were in support of this, and I agree, so I would like to move this out as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 364, passing as is, noting the excused absence of Representative Holt. Anyone wishing to vote WR or no? Chair, your recommendation is adopted.
Thank you. Next, House Bill 1231, relating to criminal property damage. I recommend moving out of House Draft 1, and I would like to set the amount for damages at $100. So it would read, page 3 at the bottom, remove the words regardless of the cost of the damage and put in there in an amount exceeding $100. And for purposes of discussion and moving it forward, I would like to defect the effective date to 6/30/3000. This is very, I think, timely for us to move this forward. I think it does merit further discussion, but with those changes, I would like to move it out. Questions or concerns, members? Representative Souza.
Thank you, Chair Tarnas, for hearing this bill and for wanting to pass out the bill. And you know, this bill is critically important to address the smash and grab incidents that have occurred in my district in Kapolei and across the state of Hawaii. So thank you.
Certainly. Thank you for introducing the measure. Any other questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1231, passing with amendments, noting the excused absence of Representative Holt. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you very much. Next, on House Bill 1325, very important measure, and I appreciate the introducer bringing this forward. Though in the testimony it became very clear that it would be best for us to defer this measure and request that this measure be taken up and considered by the Hawaii Rules of Penal Procedure Committee that the Hawaii Supreme Court has a Penal Rules Committee that reviews the Hawaii Rules of Penal Procedure, and especially Rule 40, which is the existing means by which prisoners may petition to set aside the conviction based on newly discovered evidence or any ground which is the basis for collateral attack on the judgment. It's clear that Rule 40 does need to be updated. The language in this bill offers a great starting point for that discussion, and so I would recommend that we defer House Bill 1325, and I accept the Hawaii Supreme Court's willingness to bring this before their Penal Rules Committee for review, consider whether to incorporate the criteria in the bill into Rule 40, so that courts would have more specific guidance. And so that's my recommendation, and thanks to the introducer of the bill. Okay, let's move on to the next measure. House Bill 1440, another very important bill to update something that needs to be updated. However, this is also very complicated, and it's going to take more than just this bill to be able to do it, and there was a clear willingness from different organizations, the Attorney General, the Judiciary, Department of Human Services, and the State Council on Developmental Disabilities, and others, to discuss the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. We also have national experts willing to help, so everybody's willing to help. And so I recommend to defer House Bill 1440 and urge all of these organizations to move forward with this discussion and come back next session with the recommendation on how to proceed. And I look to the organization, specifically the State Council on Developmental Disabilities and Daintry Bartoldes, to help facilitate and convene and lead this effort going forward. You are the experts in this area, and I think you could really bring together the necessary stakeholders to make it happen. So with that, members, I'd like to defer House Bill 1440. Next, House Bill 913, relating to the Natural Energy Laboratory of Hawaii. On this measure, I would like to take the recommendations of the Natural Energy Laboratory of Hawaii Authority. On page 2, on page 2, line 2, delete the word county, so we don't cause a disruption in how they've been doing business there in the, at NELHA, the Natural Energy Laboratory of Hawaii Authority. I would also like to delete page 2, lines 5 to 9, and instead I would like to amend HRS 227D to add a member of the oh no, I have to get the name, University of Hawaii Institutional Animal Care and Use Committee to the Research Advisory Committee of the Natural Energy Lab Hawaii Authority. And I make some technical amendments as well. I did get the prior approval of the the chair of the House Energy and Environmental Protection Committee for that, these amendments. With that, questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 913 HD1 with further amendments, noting the excused absence of Representative Holt. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you very much. Next, we have House Bill 522, relating to emergency management. I heard the testimony from the Hawaii Emergency Management Agency, loud and clear, and I welcome their willingness to work with the Hawaii Association of Broadcasters to recommend amendments to HRS 127A that address their concerns while preserving the emergency management agency's ability to act. At the same time, I'd like to move this bill forward as well. to really compel this discussion to take place. I'd like to retain the defective effective date, so I want to move it forward as is. That's my recommendation, members. Questions or concerns? If not, Vice Chair for the vote.
Voting on House Bill 522 HD1 passing as is, noting the excused absence of Representative Holt. Anyone wishing to vote WR or no? Your recommendation is adopted.
Thank you. Finally, last bill on the agenda, House Bill 1266, relating to food donations. I would like to actually make one amendment, and that is to make a clean effective date, effective upon approval, and move it out with House Draft 2. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1266 HD1 with further amendments, noting the excused absence of Representative Holt. Anyone wishing to vote WR or no? Chair, your recommendation is adopted.
Thank you very much. Members, that's the last hearing for the week. Aren't you so happy? You've been very good, and testifiers, thank you very much for your part in this legislative process. We will be having 3 hearings next week, Tuesday, Wednesday, and Thursday, and so I look forward to everyone being back then. There being no further business before this committee today, this hearing is adjourned.